So, welcome everyone again to this session of Knowledge Series. So, first of all, I would like to welcome Karan. Thank you so much, Karan, for taking out time for this session and being with us specifically for the startup. So, let me all introduce Karan to you all. So, he's an intellectual property rights attorney, IP and legal head at Vakilsearch. He has done his PhD in media from NLSR University, Hyderabad. Karan is very much experienced in filing IPs and helping startups in having their IPR. And it is very important for all the startups in order to understand what is the importance of IP, how it could be encouraged so that you can have your products, you can have your innovation within yourself and you can use it efficiently. So without taking any further time, Karan, I would again welcome you once again to this session, and over to you. We're looking forward to a very great session where we can have all the questions and interactions from the startups. And we're hoping that it would be a very fruitful one. Over to you.
Thank you, Aryan. Thank you for the introduction. It's a pleasure to be here on this platform among all the bright minds and the innovators and the inventors, I would say. So, okay. I think Aryan has already given a brief introduction about myself. So let me just share my screen and then we can start. Just give me a second. Hello. Aryan, can you see my screen?
Yeah, the screen is visible, Karan. Can you put it in a slideshow mode? Yeah, perfect. Perfect.
Okay. So, hello everyone. So, the major aspect that we want to discuss is whenever you are starting your business, whenever anybody is launching any new ideas, the most important aspect in your business is your idea. Even a small idea can make millions and billions, and even if you create a new product also, it might not even work. So at the end, your entire business is revolving around a small idea. What IP is? IP is a way of protecting that small idea. IP can be break down into like 5, 6, or 7 aspects like trademark, copyright, patent, design, trade secrets, and many a few other things, which it can be break down into, which in a different ways protect that very small idea. I think most of you people have already applied for some other kind of a trademark or copyright or something. But again, during this session, we're going to be discussing briefly about different kind of IPs that are there and that you should take it up. Normally, everybody who's starting up their business, they know, okay, I have to apply for a trademark. So they apply for their brand name and that's it. So today we're going to discuss, okay, that one brand name is not enough. There are various kind of trademarks, various copyrights, various designs and patents that everybody requires in order to ensure a 360 degree of IP protection. So giving you a brief introduction about Vakilsearch. Again, Vakilsearch was started around a decade back with the idea of making legal simple. Legal or the professional services simple. So normally basic concept in India, you need to get anything legal, you need to find a lawyer, you need to go to a court. So that has been the older concept and it's like hard to find a lawyer. So it was started around 10 years back to finish that basic mentality that a lawyer can be now reached out online also. You don't need to personally go and meet a lawyer or a CA or a CS. You can meet them online and take up your business and clarify your queries. So that accessibility aspect, Vakilsearch was conceptualized to bring that accessibility to the entire population across India and also internationally also. Obviously, secondly, with respect to the pricing, transparency, and speedier processes. So again, Vakilsearch is trying.
In progress.
Okay. So yeah, Vakilsearch over the period is trying to bring in tech to speed up the processes rather than going with the paper kind of a system. So yes, whatever processes there are, whatever legal requirements there are, we are going everything paperless. So that's where we speed up the things for you also and for us also. So on all those aspects, we try to resolve a few major legal loopholes, and that was the basic conceptuality the Vakilsearch was started. And currently, yes, its name is no more Vakilsearch per se. It has been rebranded as Solvit for everybody's reference. Okay. So yes, with respect to IP, as I was saying, it's simply an idea that you try to protect in different ways. So these are some of the ways that you can see on the screen how you can protect your IPs. These are some broad heads that you need to take care of when you are starting your business. Most of my clients or my customers, they ask me, sir, I'm starting my business. IP protection, when I should get it done? It's not should I get it done now or after I launch my business after 6 months, I will get it done. I need to put my money into this. So my suggestion to my opinion to all these clients or all the people who are getting into new idea, as I said, the entire value of a business is your idea. And if your idea is itself not protected, you might right now jump and start off your business at a very high scale, but after 6 months, 1 year or 2 years, it will die down. Reason being, your crazy idea would have been taken up or imitated by 100 other people. So you would be one among thousands and nobody will be able to recognize you. If you have to stand out and be the one, so you have to make sure you apply for the IP before you apply for the company registration itself. Before you launch your business, you have a unique machine that you have created, apply for the patent. If you are into a content generating or an education based model or business, apply for the courses copyright right at the front before even launching it or putting it on your website accessible. If you are into what do you say, if you are creating into mobile applications and you have created a unique mobile app, apply for the coding apply for the registration of the coding altogether before you even launch your app on Play Store or any other platforms. That's the point. If you want to stand out when you're launching your business, you have to make sure that your idea is only yours idea. It cannot be taken up or imitated by 10 other people. So moving on to that aspect, like first is the trademark, which I feel many of you would be already knowing. Trademark can be bifurcated again on various different aspects: tagline, brand name, logo, packaging, sounds. These are different kind of trademarks that are already there. So again, everybody is currently, as of date, are either applying for a, what do you say, the brand name per se, that is, for example, IKEA, or the logo of it. This is, people have normal common knowledge as of date. The next most important aspect that people are still not doing is their taglines, I would say. Every business is currently run on market-based advertising, and you need to create catchy lines or catchy statements which get customers to you. And if you come up with such a catchy line which you feel can be your attracting point, why not apply for a trademark for the same? If you have come across a line or a slogan or a tagline which you use it specifically for your business, apply for a trademark for the same. So that nobody can use the same hashtags, nobody can use the same on any kind of social media platforms or e-commerce platforms as an attracting point. So that's where the taglines comes. Similarly, packagings. Everybody in the industry, I would say a good 50-60% of the industry is into a product-based industry. If you divide industries like into service-based industry and a product-based industry, at least 50-60% are still into the product-based industry. For those people, every product has a unique packaging. Every product has a unique packaging. So I will just go ahead and show you one example. So like this Coca-Cola bottle that you can see, in this middle, there is a label that is found, or in a Bisleri bottle, there is a label that you find. All these are unique labels or products or packaging of your product that you have created, unique color combination. That is how your product looks from outside and attract consumers or customers. You should apply for the same too as a trademark. That's called a label trademark. So even that is a thing that you can apply. So again, these are few aspects. My point is, whenever you are applying for a trademark, yes, try to find a way how you can stand out from others. Don't apply for a very generic trademark. Don't apply for a very generic trademark. For example, you are into sale of laptops, so don't come up with a fasty laptops, something like that. Again, my point is, don't come up with very generic or simple or very common in use words. Trademark registry has a very basic requirement that your mark has to be unique. It has to be, they prefer if the mark is a non-dictionary word. If you want your trademark to go in a speedy manner without any objections, come up with a non-dictionary word. And I'm not talking about changing the spelling of a dictionary word. I'm actually talking about coming up with an absolutely new brand name altogether. The benefit is, firstly, yes, it will go through trademark registration and approval very quickly, and you will be able to ensure that nobody else comes up with the same brand name. Secondly, unique or crazy brand name sticks in consumer minds. It's a generic word or a common in use word name, it doesn't stick. If you come up with something which is uncommon to your industry, it sticks to the mind of the consumers. So come up with something crazy when you apply, and obviously if you are coming up with some non-dictionary words, it will have an easy going through at the trademark registry. Obviously, it's a major asset. It's a major asset whenever you're launching your business. Whenever you're launching your business and there is an evaluation happening, or you're pitching it out to somebody else, or you're pitching it out to investors. Yes, having a proper IP protection on all points, be it trademark, copyright, patent, designs, having all these adds to your evaluation. How to apply? Again, you can reach out to any trademark attorney who will assist you in applying for a trademark. Basic validity is around 10 years. The basic time that you can get your trademark can range between anywhere between around 7 to 8 months to around 2 years. Okay. I'm not going into details of the process of application, but yeah, again, basic, it's like across all the basic, be it trademark, copyright, patent, or design. Basic stages are you apply for them, they are examined by the government department, they raise the report wherein they raise whatever the issues they have. We have to file a response to the same. After that, they appoint a kind of a hearing. After the hearing, they will either approve your trademark or copyright or design or patent, or they will accept it. Obviously, there are some differences in both the processes for be trademark, copyright, again all the four. But yes, superficially, if you would ask me, this is how the process goes. With respect to copyright, okay. With respect to copyright, as you can see, it's copyright is anything, any original work that you can put down on a hard paper or in a digital format. Any kind of an original work or a unique creative work you can put, that you can copyright it. These are some of the examples. You have written a poem, you can copyright it. You have created a song, you can copyright it. You have created a video, everybody is creating content-based marketing, you can copyright it. You are writing a unique computer software, which is the most common businesses, everybody is having some of the other IoT or the tech-based involvement. The most common, the most and the easiest way to protect the basic software and the coding of it is through computer programs. So again, you copyright the entire software coding of your whatever your application or your unique software that you have created, and you can apply for the copyright of the same. Many of the clients, they come up and ask me, sir, I have come up with a unique tech-based or a software-based product, and what should I do? How can I protect it? Can I apply for a patent or the same? And even some of you might have that question: can I apply for a patent for a software-based product, or how to protect it? So firstly, in India, as per Indian patent laws, I'm just overlapping it a bit. In Indian patent laws, a software per se cannot be patented. If you have a unique software, you have a unique coding, you can apply for the copyright of the same. The only way a software can be patented in India is if we can show there is an additional hardware through which that software is corresponding and working. So we have to showcase that there is a hardware involved in that software that has been created. Once we are able to showcase that, yes, in that case, we can apply for a patent for the same. But yes, even for the people who do not have any kind of unique hardware involved in it, Please, it's copyright law is one of the strongest of all the IP laws in India. Reason being, it's almost like eternity. So once you apply for the copyright and you get the registration, it's almost like eternity, as in for the entire lifetime of the author and plus 50, 60 years after the death of the author. So that's a massive timeline. Okay. So for which, and second aspect is copyright. Once you apply in any one of the country, you can get it enforced in around 170 different countries. So India is part of Berne Convention. It's an international association wherein if you even apply the copyright in India, if somebody is copying your rights in UK or EU, you can take action against them on the basis of the same. This right you won't get in any of the others, be it trademark, copyright, or patent. This is the only protection that you get in copyright. That's why I say on the basis of these two aspects, it's one of the most strongest protection of all. Again, what all rights? Again, right to reproduction. Once you copyright, right to adoption, right to communication, right to public performance, and many other aspects. You get exclusive right over the same. Okay. Coming to the aspect of patent. So patent is, yes, it's like protection of any unique product or a process or a unique technical solution which is solving a problem which has not been solved before, or which is solving a problem in a way it has not been solved before. That you can apply for as a patent. There are three basic quantifications that you need to take care of when you are applying for a patent. Firstly, it should be new. It should not have been made public. Secondly, the idea should be it should not be it should not be an obvious development. It should not be something common in knowledge. It should be unique. Third aspect is industrially applicable. Yes, the product should have some industrial applicability that somebody will actually buy. There is some use of the product. These are the three basic criteria that we have to check when you are applying for a patent. The process, machine, article applied for as a patent. Okay. Again, the basic process for patent is, again, you have to apply before you even apply for a patent application. You need to do a proper patent search. You need to conduct a detailed search to find out if similar kind of patents are already existing in the market. So the reason being, if few people have even gone for a patent search, you do a search, you will get to know there are 4 to 5 patents which are actually similar. Now, what to do? Should you stop your business? Should you stop what idea you have created? No, you should not stop it. Yes, there will be some other kind of similar kind of inventions in existence. What you can do is you can find out the unique aspects or the differentiator from the existing patents. Or if you do not have any differentiator aspects as of now, some differentiator aspects that you can add and research and R&D in the next 2 to 3 months and make those additional aspects and showcase that the end result that your patent is providing is absolutely different than what are the current solutions present in the market. That is the basic, again, that is what when you do a patent search, at least in 70 or 80% of the matters that I come across or we do the patent search of, the basic first opinion is no, sir, you cannot do it because there is already something existing. But the next after that is having a detailed discussion wherein we come across various aspects which are very unique to their business or to their product or to their invention. So whenever you are applying for a patent, get into a detailed discussion with a patent lawyer to show the differentiating aspect that you have created for your own product. That differentiating aspect is what will get your patent through. Okay. So again, you get the right to use the trade. You get the right to exclusive use of that invention. No doubt on the same. Again, you can stop others from who might be copying or who might be manufacturing or might be selling your invention. You can take appropriate action against them. Also, a patent is valid for almost 20 years, and that's again with the kind of development and the new tech that is coming up every after every gap of every 4 years, I would say 20 years is a very lengthy period to get exclusivity over a specific invention. So again, these are the various kinds of patent applications anybody can apply. So such as a provisional patent, like basically, if you would ask me, there are two most important kind of patents. One is provisional and other is complete specification patent, which is most commonly applied. So again, provisional patent is something like you have an idea, but your R&D is not complete, but you want to ensure that your patent is protected. You have applied for the same, nobody copies it. You apply for a provisional patent application with half-cooked R&D to get your idea secure, and you get 1 year to file the complete details about the same. In case your R&D is complete, your product is ready to launch, and there's nothing else, any information or any technical details that is required, you have it. In those cases, you can simply go ahead with complete specification patent, which is having all the details. Then again, then there is PCT application also, wherein if you have a patent in India and you want to expand and get rights across internationally, you can file through PCT process, wherein you apply for a patent in PCT application in India, mentioning which all countries you want right of your specific patent. So that's a separate process that you can go through. And there are a few other patent, different varieties of patent application. Obviously, when you have again all these pointers, when you start talking about your invention to a IP lawyer or a patent lawyer, they will advise you which is the best way to go ahead with your application. So yes, as I said, you have to conduct proper searches before applying for a patent, which is very crucial, because patent, to be very candid, is not a very economical process. I would say is very like 5,000 or 10,000, a very nominal amount matter. It involves time, effort, and money of both the lawyer and yours. Everybody has to spend time on it. It will take time. So make sure before you even go for applying to the patent, get a proper search done to know if there are any kind of similar patents already in the market. These are the three different kind of searches that we do. Majorly, we do like patent search itself. Then there is like freedom to operate search to know it's a kind of a more detailed search wherein you try to search any kind of infringement happening on the basis of the claims, or there is evidence of user search wherein you find any kind of actual user of a similar patent in the market. So, but again, if you are initially applying for a patent and you for application purposes, anytime you just go for a patentability search itself. So again, the basic process of patent is same. You file the patent. You file the patent. It gets published. After the publication, you have to file a request for examination. After the request for examination, the patent gets examined. After the examination is done, and you have to file the response. Once the response has been filed, then they will allocate a hearing. You have to attend the hearing, and after that, there will be grant of the patent. In all these processes, be it trademark, copyright, or patent, or the design, if we come to the most, kindly remember there is an aspect of opposition always there, where any third party can oppose your patent, where any third party can oppose your trademark, wherein they feel that your trademark, copyright, design, or patent, they are similar to yours. They feel that you are violating their IP. Similarly, you can even initiate such IP infringement actions against different individuals. If you come across an instance, you need to do this because, again, coming back to the first point that I said, you need to maintain your exclusivity. If you have the exclusivity, you'll have a booming business. If there are 100 players like you doing the same thing, your exclusivity is of no value. Your business idea that you created is of no value. So again, the point is, once you have applied for IP protection, once you have applied for a trademark, once you have applied for a copyright or a patent or a design, the next most important aspect is to make sure that it stays protected and nobody starts copying the same. is a most crucial aspect to it. Coming to so again, anybody is wearing any kind of shirt, what are the pattern of the shirt, you are wearing a watch, ring, the shape of your ring. So any product which has a shape, from noodles to the shape of a chocolate to the shape of a laptop or to the shape of a unique kind of a hut that you have created, or headphones, whatever, any tangible based product that you create and has a unique shape that you designed, your team designed, can be design protected. So as this design shows, the shape of a shoes can be put as a design. The shape of this bottle, the shape of this bottle per se can be design protected. This label, as I said initially, will be a copyright, will come under label, trademark, as I said. But the shape of this bottle, the shape of this bottle per se will be design protected. Each and every business, you pick up any one or two or three business, each and every business has at least 3 to 4 IPs to protect. But people are not aware of the aspect of like to one, trademark everybody. Second, okay, I have to get a patent of it. So point is, get into a consultation with an IP lawyer to do a kind of a due diligence of their business. So due diligence is an aspect wherein they will analyze your business, what all businesses you are doing, what are the mechanisms that you are doing, what is your brands, what are the sub brands, what is the exact business. They will study your brand exact business, and then they will suggest, okay, these are 10 different IPs that you need to protect to ensure you have the right over the same. And nobody, your competitor or your employees who is leaving you, they take that idea along with them. So yeah, this is what design is. Again, the process is very similar to again what others have. But yeah, this is the basic process of design, patent, copyright, and trademark. There are other aspects of IP also there, but again, they are not much used, such as geographical indications, trade secrets, plants and varieties. So again, these are not per se which is much required, but geographical indications. So like Pashmina shawl, or there is a unique kind of a mango which can be grown in one area. You can apply for the geographical indication of the same to get exclusivity. Trade secrets. So trade secrets is like you protect your IP through an agreement or contracts, or very strict IP contracts. Plant variety, so a unique plant or variety or that has been created or founded or specifically created by merger of few things. So all those aspects. Normally, people have to care about in the current industry or in the everybody's working in. Trademark, patent, copyright, and in the design is something everybody should take it up and to see how they can ensure its protection once they have applied. The most important aspect I would like to add here is, yes, once you have applied, don't stop protecting it. You have the exclusivity over it till it is protected. So take adequate steps for the same. Take care. And third is searches. Whenever you are applying for any of these aspects, be it trademark, be it design, be it patent, have a proper search done to know what is the threats, what are the threats that you might come up in the future, that you might come up seeing from your competitors, so that you can do a threat analysis. Okay, these are the instances that they might come up and how we can take action against them if it come up. Are you ready to give up your brand name, or are you ready to fight it out? So these are the aspects you need to do before launching the brand name and not after launching the brand name. I hope I have been able to clarify the basic pointers and questions. Rest again, we can take up some questions and then we can continue it from there.
Sure. Sure, Karan. So there were a few questions in the chat. I will start with Mohammed Salman. So they have a question like, The startup CC Precast Solutions Private Limited has 8 patents. Okay. And they needed to know how we can take more benefits out of it. Like they have a product on patent. So they wanted to know how they can avail more benefits out of the already existing patents.
So again, Aryan, so again, to reiterate, so one of the client, I'm not able to see the chat on
Okay,
the.
so one of the question was, I guess if the founder is there in the call, they can bring the question directly.
Yeah,
So
that will be helpful.
yeah, so they have a question like they have 8 patents on the company's name right now, and they wanted to know how they can avail more benefits out of those patents. They have a
See,
product
okay,
patent.
got it. See, one of the most important aspect about patent is how you can monetize it. So you have applied for the patent as of now. You have applied for the patent as of now, and you might be selling it. See, it's a patent's life is very short, 20 years, as I already told you. You need to license it. That is the most easiest and the best way that you need to take to actually start licensing your patent. You license your patent, get into a license, IP license agreement with different individuals, different vendors, different companies, and start giving them the license that they can use this for selling this. So again, you are simply weighing again, what do you say, diverging your business. You are creating a McDonald's brand. You license your brand, you license your idea. That is the best way how you can create monies, how you can create what do you say, income out of your patent and not restricted to just yourself, to make it available to other different entities.
Got it. So I guess this pretty much explains. Salman, if you have any follow-up questions, you can ask directly now. Meanwhile, we have another question from Meeta Vachan. So they are specifically asking that what is the difference between Creative Commons licenses and copyright? So especially in the context of knowledge outputs like reports and content creators, writers.
Okay. See, again, whenever you are creating the content through content writers or through different content writers, obviously you have to enter into a specific agreement with them. So they are working on work for hire aspect. So any and all content that they are creating at the time of the contract itself, they are giving you the exclusive right over that content. So they do not, as the author or even the content writers, I would say they are the author, but they are working from you. And at that stage, they have already given the exclusive right for the same. So you have the exclusive right to using that content in whatever manner that you want. And obviously, that content being done through content writers or anybody, you can apply for the copyright for the same. You can apply for the copyright for the same. And when you apply for the copyright for the same, you just have to take care of two things. When you're applying, you have to mention who is the applicant. That is you. That is Mr. Mithwachan. You are the applicant or you are the owner. Then there is a requirement. We have to mention who is the actual author. And we have to get an NOC from the author, which specifically states that Mr. Mithwachan has the exclusive right over this created content and he can use the same. That kind of an NOC has to be created. If you have that kind of NOC or a clear agreement with your content writers specifically, or anybody who is creating a knowledge content for you, you can have an exclusive right over the content created, and you can apply for the same under Copyright Act.
Got it. So we are always welcoming the follow-up questions. If you have, we can directly ask right now. The third question that we have.
Yeah, can I quickly follow up on that?
Sure.
Yeah, thanks, Karan, for the information and the presentation as well. Thank you for that. See, I mean, yeah, and thanks for the suggestion on the content writers and how we can use. But my question is mainly about, see, some of the work we do, we publish it, okay, on the website as a report or some kind of small article or something like that. Okay, these are kind of a research kind or kind of advisory kind of articles. Okay, but often we just go for Creative Commons licensing. Okay, I mean, we say whoever uses it, they have to cite us. I mean, give reference to this source, but they can use it. but we are not sure whether this is a good thing or we need to go for copywriting or if you could give some more indications on this matter, maybe it would be helpful.
You are saying, so okay, you have created articles and so you are giving other people licenses. Okay, you can use our content, but you have to give credit to us. Correct?
Yeah, exactly. Yeah. But
So again,
I don't know whether it's a good thing or whether we'll end up with some issues because some other people, I don't know how they use it. They might use it for the commercial purposes. We don't know. We go for Creative Commons licensing that says they should not do, but we are not, legally registering or taking copyright, right? So I don't know whether it would be binding when we just insert a sentence from the Creative Commons license, this website. So I don't know what are the pros and cons or the risk involved in these kind of things. So it would be helpful if you can clarify or give some.
See, on this aspect, firstly, if you have created the content and you're putting it on the website and anybody is taking your content and posting it upon their website, firstly, you should not do it for free. Okay? If you are, for example, there are news platforms. If your news platform are writing 100 blogs in a day, if somebody else is using those blogs, you should get some kind of a royalty or an annual or a monthly contract that you have to. If you are going to put up all our content on your own website, you need to make some payment to us. You need to make 50,000, 1 lakh, whatever payment, again, depending upon the kind of content that you have paid. Reason being, in the reason they might be coming it to you is your content would be good. People are searching for the specific content. That content is having traffic. So what will happen if you are giving it to open license to 50 people to use your content? You are diverging the traffic from yours to all those peoples. So the people who are searching for a term and they were just seeing you, now they're seeing 20 other people. So you have to analyze on a business aspect. Okay, if this content is so unique and the traffic that I'm gonna get is something crazy, then no, you should not give the licenses for the other people. But if yes, you are able, if you feel that you can monetize it by giving it to somebody else, why not? But you should monetize it. You should monetize it. You should not give it away for free. For sure.
Okay. Thank you. Yeah, thanks.
Thank you, Karan. We have few questions. Like some were asking about contents on ChatGPT, like the content that we get on ChatGPT, if they use those kind of content directly in their websites. So will that be creating any copyright issues or any kind of that regulations problems?
No, it won't create any kind of issues. Yes, everybody is right now using ChatGPT created blogs and contents. It won't create any kind of copyright issues, but you cannot, I would say, per se claim exclusivity over the same. Again, that is not something that uniquely that has been created by you. You're not the author. So if you try to file a copyright application for the same, you won't be able to showcase, okay, this has been created by you. Okay. Obviously, there are loopholes to it. So there is no way the copyright office will be able to get to know that this content has been created by ChatGPT per se. But yes, it is always advised if you are writing the content on your own, apply for the copyright for the same. If you are creating it through these open source platforms or ChatGPT, yes, you won't be able to claim like exclusivity of the content that ChatGPT creates. You won't be able to show or go in the background or show how you created the content.
Got it. So
but yes, you won't face any legal issues from ChatGPT or anybody else.
Okay, so it applies to any content that we're getting over the internet, any type of bot or any type of, say suppose, websites, or it applies to all of them?
Yes. See, whenever you're applying for copyright, again, I'm correct, I might be not getting your question right, but still, with respect to copyright, you can apply for any kind of content. You might have various pages mentioned on your website about a product, detailed description about your product, or any kind of content that you have on your website, you can protect it under copyright. But yes, again, if you are getting it through any kind of an open source platform, you cannot apply for the copyright for the same.
Got it. So Ramesh, this was your question. If you have any follow-up to be done, you can ask it over here. Apart from that, Karan, I have another question. Another good question, actually, which a lot of startups have this dilemma. So they're asking that what is the best way for an IP filing? Like, is it okay to go with an attorney or an IP agent to form an IP, or it would be suggested to go ahead with any agency, to onboard any agency where they charge a lot. So, as an attorney, what will be your suggestion in this regard?
See, obviously, you need for patent filings or be it trademark or copyright. Firstly, yes, you need to get a specific IP attorney to handle it. There will be many people who will be saying that they can get it done. There will be many lawyers also who will be saying that they can get it done, but they're not IP specific lawyers. So again, everybody understands basic aspect of law. There is criminal, there is civil, there is corporate. Okay. And then there is IP. For civil or criminal, a same lawyer can handle both the kind of matters. But handling IP, it's a unique, specific field, like patents, like designs. People don't understand all these aspects. Normal lawyers even don't understand all these aspects, let alone any agency which is started by a CA or a CS. They won't understand all these aspects. So whenever, again, if you are coordinating or getting these things done or filed, make sure that company has a specific IP lawyer, not a lawyer, not a CA or a CS. Many company goes to the CA or CS and they get it done. Please don't do that, because their role is accounting and not patent filing and other things. So don't go to a CA or a CS, because the costing will further obviously increase for you, because they won't be able to do it. They will still give to another IP lawyer. Reach out to an IP lawyer directly at your own end. As I said, this Vakilsearch or Solve It, this is a platform that is trying to bring you close to any and all people, all the lawyers for different fields. Reach out to an IP lawyer directly to handle these aspects, not through an agency or something. Or even if you're reaching out to an agency, make sure they have an IP lawyer within their ecosystem who can help you out.
Got it. So, few more questions over here, Karan. Like related to this, like as is in the case of IP filing, a lot of government organizations are helping people in filing IPs, and which charge basically lesser than the corporate people who are specifically filing IPs with a little bit higher margin. So, what would be your suggestion in this case? Like, because it's a case of a user case, it depends on the user specifically. As an IP attorney, what would you suggest? Is it better to go with the government, or it's better to go with the professional corporate people?
See, again, there are various government schemes in motion as of date. There are indeed many government schemes that are in motion for protecting of the IPs. Okay. But there are two aspects to it. Firstly, yes, like for all startups or MSMEs or individuals, if you're applying for any of these, like trademark, copyright, patent, design, there is a massive reduction in the costing. Even for the trademark registry, like for example, you are applying for a trademark, normal for a company who has been operating and who is a business and who's not a startup or an SM or an MSME or an individual. The costing for them is government fees is around 9,000. However, for MSME or a startup or an individual, it is 4,500. Similarly, for a patent, government fees is around 1,600 for an MSME or an educational institute or an individual. However, it is 8,000 for any other companies. So this is a kind of benefit that government has already provided. So if you are reaching out to any of your IP attorneys, and if you have an MSME registration or something, make sure to inform them, yes, I have an MSME registration, I need the government granted discount. So many of the lawyers, they won't inform you, okay, under being an MSME or a startup or an individual, you have a massive reduction in the costing. They might share the normal costing. So make sure when you are talking to the lawyer, you share, yes, I have an MSME certificate, or I am a registered startup, or I am an individual. So there is a government benefits you will get. Take care.
I guess that's a very important suggestion which you gave. And listen out, folks, like it's very important for you to understand. You can save a lot of money in this regard. So thank you, Karan. Few other questions, like well, because we know that a lot of people are applying for international patents and few are sticking to the domestic patents because it's very tedious work. But just for a common understanding, like what are the basic and the key differences between filing a domestic patent and going for an international patent? I know that's
See,
a very big segment, a very general question that I'm asking, but I guess basic differences would be good enough for the people to understand to understand the scenario, whether they should go with a domestic patent, or if they have the potential, can they go ahead with the international patent?
okay. See, with respect to, okay, Indian patents, normally, again, if you are wherever you are operating the business specifically in, you have to apply for the patent there, no doubt. So if you are having an operation in US, UK, other countries, yes, you have to apply for the patent there also. Okay. Basic patent law is territorial in nature. Wherever your idea or your machine is in operation, you have to apply for the patent in that specific country altogether.
Okay.
However, how you apply the patent, that is where the issue comes in. So when normally in India, you apply, if you are operating in India and you want to apply in India, you have to file a patent application with the patent office in India. In case you are operating from India and your products are there in other countries also, in that instances, there are two ways you can apply for the patent. Firstly, there are councils, there are specific patent councils in each of those countries. You can reach out to them and apply for the patent application directly. That is one aspect wherein you can reach out to the councils and they will apply for it. Then there is a concept of PCT patent application, wherein there is a route through which you apply for an application with the Indian Patent Office itself, stating that I want to apply for the same patent which I applied in India in these 20 other countries. Okay. So you apply for a PCT application, then a search will be done by the government organization, and then you will file separate applications or the separate processes in different countries.
Okay.
So this is how you can take it up both. My only suggestion in this aspect, on the costing aspect, I will just advise for each and everyone: if you are going internationally, if you are planning to launch a product internationally, if it is 1 or 2 countries, apply for the patent directly through a specific IP attorney, patent attorney specifically. So even Vakilsearch on board has on board around 40 to 50 different countries patent attorneys. So if you have any doubts and if you want to apply for a patent directly in specific countries, yes, you can reach out to us. With respect to PCT, in case you are going in more than 5 to 6 countries, then only PCT route is suggested. Reason being, PCT route, the government fees increases a lot sometimes. So that government fees is beneficial to us when the number of countries are around more than 6. Okay. If you are going for lesser countries, yes, it's economical to reach out to the directly attorneys and get the patent filed over there.
Got it. So, like, how much does it overall cost? Like, if you go with a PCT filing, how much it takes generally, on an average? I'm asking.
No, I would say it cannot be determined. See, every country has their own unique government fees involved. Okay. Every country has their own separate. So, like 196 countries have their own unique costing involved. So to pinpoint, some countries would have 1,000 USD, some countries would have 500 USDs, some countries would have 2,500 USD also.
Oh, okay.
So it depends from country to country.
Yeah. So another question that we had is like, in the cases of IP infringement. Okay, so say suppose if I have an entity and I have a patent and I got an infringement, like I can see that some other entity is using my IP, which I have a definite patent over it. So how can I go ahead and proceed and take the necessary steps? Like, what's the basic understanding of this area? There's a lot of things that are happening right now.
Okay, yeah, I got the point. So again, the IP infringements can be of either trademark, copyright, design, or patent. Again, there can be IP infringement of any of these aspects. So the basic and the most common, there are 2 ways. One is civil, one is criminal. In the most common, and which is common to all the ways, is finally initiating a civil proceedings for infringement of trademark, copyright, design, or patent, wherein you can go and file a case directly in a district court or even in a high court, wherein you will file a case for injunction, wherein you will asking, I want an immediate relief. You will claim for an interim injunction with a specific court. those IPs have a very unique aspect wherein you can even get a injunction or a stop to the other party from selling the product within a month from court. So you will get an initial stop from the court that during the pendency of the entire proceedings, this entity cannot sell or cannot use this product.
Okay.
So you get a stop within a month, and during the entire proceedings will keep on going on, wherein they will judge, there will be evidence stage, there will be cross-examination, all those things will keep on happening. But yes, at the very first month, you will get an order from the trademark from the court stopping the other party from using your IP. So that is one aspect of finally initiating a civil proceedings. Second is criminal. Okay. So like criminal proceedings, you can initiate, like for in trademark matters or in copyright matters, you can initiate criminal proceedings. But it is not always suggested. Reason being, what we have seen in the I personally don't suggest as a lawyer, because what we have seen in the past, in few instances, the information of the case being filed or the FIR being filed gets leaked to the infringer. So the information gets leaked, and by the time you actually go to their place and try to arrest them or try to seize the goods, what are the infringing goods? They disappear. People are not there. The infringing good is not there. So in that case, civil court is very efficient, wherein the order is kept in secrecy. The order is not made even public until unless appropriate action is taken against the specific infringer. So just for the knowledge for everyone, like in infringement proceedings or IP violation, if you initiate a case, if you initiate a civil case, just how CBI raids happen, there are raids that can be conducted in IP infringement matters also.
Okay.
So there is police, there is a local commissioner who will go and seize the entire products. Thousands, lakhs, crores of worth of product, irrespective, the raids can be done for even in IP matters if you file a case against the specific infringers.
Understood. So like if I have an IP and I got infringed, so I can, if the decision comes into my favor from the court, I can charge, I think there are some fees I can take the money from the infringer because they have used my product or my IP. So is this a thing?
Yes. So here, whenever you're filing a case, you will always claim some damages.
Yeah.
You always say some loss has been caused to me because this party has been infringing my business. So in those cases, you can mention whatever the kind of damages that you want. I would say one of the highest damages in IP matters or IP infringement matters are the ones which get one of the highest damages allocated by the courts.
Okay.
So the damages, even amount that have been allocated by courts, even have gone into crores. Not few thousands or lakhs, they have even gone into crores.
Okay.
Wherein the infringement is of a massive level.
Got it.
So yes, you can claim for damages for sure. That should be one of the major aspects.
Got it. One final question from my end. So I'm really sorry I have a few of these questions.
Please.
Just say for an example, if I'm working somewhere in the healthcare sector and if I'm making a device which has a hardware component and a software component. Okay. So what would you suggest as my attorney? Is it better for me to have a one complete patent on both of these aspects, covering the hardware part and the software part? Or it would be good for me to have two different patents, one on software and one on hardware? And how can I make a decision how these, I have to make a single patent or I have to go for two different patents? On what factors can we decide this?
Okay. See, Aryan, again, this point even I said earlier, for a software, you cannot apply for a patent in India.
Okay.
In US, UK, EU, or other countries, you can apply for software patents as per the local laws over there. In India, you cannot
even apply as a copyright, right? Like for a software.
In India, you can apply it as a copyright. Okay. Exactly.
Yeah.
You can apply the software as a copyright. If you have a hardware and software which are working together, you apply for the same together as a patent.
Okay.
Even if you have a smallest of hardware involved in it, you have a unique button to make that software operate, or a unique kind of a device which makes that software operate. Apply for a patent. However, yes, again, if on the separate aspects, if you're saying that they're separate, so like software per se, No, you cannot apply for a software per se individually.
Okay.
In India, again, there are many companies who are wanting to apply for one, still presses upon they want right over the software. In those cases, I always say, sir, let's apply for the patent in USA. Apply for the patent in USA. You get to know, even if some dispute at a later point of time happens, you can show that even internationally, I've tried to protect this right. Indian law doesn't allow, but internationally, I have applied for the software.
Understood.
With respect to the hardware separately, yes, if the hardware is able to operate individually without the use of the software, yes, you can even apply for the same individually. Why not? Why not? 100%.
Understood. So that's all, Karan, from my end. If we have any questions from the people who have joined for this session, we're happy to take 1 or 2 more questions in this regard. If you have any question related to IP, any basic questions which Karan already covered, you can have all it clarified in this session particularly. Otherwise, what you can do, like if you have any questions or if you're interested to file an IP, you can just write back to us and we can connect you to Karan directly and you can go ahead with your IP filing process and everything. So thank you so much, Karan, for being a part.
Sorry to interrupt
this
you.
wonderful session. Okay,
Yeah.
Pradeep,
Can we have Karan's email ID? Hi,
Karan, can you please drop your email ID in the chat?
Sure.
Thank you.
So thank you so much, Karan, for taking this wonderful session. And we're quite happy to have you in this cohort. So yeah, clarified a lot of questions, and I'm quite sure if we have any further questions or if the people have any further questions, I will definitely write it back to you and get it answered from you as well. So thank you so much for being a part for this knowledge series. And I thank you once again to everyone for being a part. Can we just open our the switch on our videos so that we can have a picture for this? It would really mean a lot to us. Can we please turn on our videos, please? Okay, thank you so much. Thank you so much, everyone. Have a nice day. Thank you, Karan, once again.
Thank you, Aryan. Thank you, everyone.
Thank you. Bye-bye.